Hello, dear students. I'm Swati Singh Parmar, Assistant Professor, Dharmashastra National Law University, and I would like to discuss with all of you the international law related part for your CLAT preparation. So, for CLAT, as you would know, that in the legal reasoning section, there are questions on different areas of law, including criminal law, constitutional law, contract law, tort laws, international laws, and otherwise. And out of these, as I said, that international law is one of the subsections, so we'll discuss about international law. And in international law, there are various portions from which you may expect questions in your CLAT UG exam. So out of those, we first begin with our first topic in international law, which will be nature, kinds, and sources of international law. So this is the first lecture on international law, this is more of a introduction of international law, its characteristics, features, etc. That will prepare a base for all of you to understand the international law questions, as well as there will be direct questions also that you can expect from this portion in international law. So let us begin. In this discussion, we'll focus on first the nature of international law, then we'll see a distinction between public and private international law, then we'll come to kinds of public international law, and then the sources of international law, and finally we'll see few questions through which we assess what are the takeaways from our today's discussion. So let us begin. Now, what is international law? So in simplistic terms, international law is a law or a legal system that governs or regulates the relationship between various states. So there's several states in the world, several countries in the world, and how they interact with each other in terms of their social, political, economic, and other relationship. This governing of their relationship is done by international law. So international law in that sense governs or regulates the state-to-state interaction. Right? And in most of the definitions of international law that you'll find by various scholars, they define international law in these terms, in terms of state, in terms of regulation of state behavior. And state behavior, what kind of state behavior? State behavior not inside the state, but outside the state. That means that when a state interacts with other states of the world, how that interaction will take place, that is governed or regulated by international law. So international law conditions or regulates or governs the relationship between various states of the world. This is the simplistic understanding of international law. And by this simplistic understanding, we'll try to see what are the features of international law. But as I said that this is a simplistic understanding, I mean that in very rudimentary form, international law was seen, and it is continued to be seen so, as a law regulating the behavior of state. Unlike domestic law, which regulates the behavior of people like you and I. So domestic law regulates the behavior of individuals, right? Individuals would be the people of the state. So for example, if you talk about traffic laws as an example of domestic law, traffic law tells you to wear helmet, tells you to stop at red light, to slow down at yellow light, to drive on the left or right direction side of the road, depending upon which country's traffic law are you talking about. So these are the directions or duties that you are expected to observe under traffic laws. So traffic laws in that sense apply to individuals. Similarly, if we talk about Contract Act, the contract law regulates how contracts will be formulated between individuals or in sometimes between some corporates. So the laws that are essentially domestic law, for example, traffic law, laws, criminal laws, procedural laws, these are for individuals of a state. And therefore, these in these laws, the subject of these laws are individuals. While, as I said, for international law applies to states primarily. That is why the subject of international law is state. So what is the subject? When we read any law, we see two basic terms being used in describing that law. One is subject, another is object. So let's first see what is object. Object means objective or end or the ultimate goal. So what is the object of penal laws? The object of penal laws is to penalize the criminal offenders so that society is as far as possible crime free, or so that the society in society the crime is reduced. The object of criminal procedural laws would be to prescribe the procedural things that are to be followed while in a criminal prosecution, right? The objective of traffic laws would be to regulate the smooth functioning of traffic in a state. So object is the objective of any law or aim or end of any law. While on the other hand, subject would be those entity upon which the law enforces or upon which the law applies. So in case of Indian Penal Code primarily applies on Indian nationals. So for example, if Indian Penal Code talks about the crime of theft, the crime of robbery, the crime of rape, murder, gang rape, dacoity, etc. So all these crimes would be crime for the purposes of Indian nationals, right? So it primarily applies on Indian nationals. So Indian national would be the subject of Indian Penal Code, although there are few exceptions, but we'll not talk about them right now. Again, taking another example for understanding what is subject. So if we talk about traffic laws, again, the traffic laws of India will apply to Indian nationals, right? If we take another example, let us say take example of the tax laws. So Indian Tax Act, Indian Income Tax Act will apply to the Indian nationals for the purposes of their income tax and deductions, etc. So the entities upon which a law applies would be the subject of that law, right? So we talk about, let us take a fourth example of this, Hindu Marriage Act. So Hindu Marriage Act would apply to the Hindus, be it inside India or sometimes the Indian Hindus who are now settled abroad, right? So these are the subjects of these laws that I just took example. Now, if we talk about subject in international law, as we just discussed, the subject of international law are states. So international law primarily was conceived as a law to regulate the behavior of states with each other. That makes state the subject of international law, unlike domestic law where individuals are subject, right? Now this very facet, that the subject of international law is state, while the subject of domestic law is individual, this makes international law very different from domestic law. And why I say so? Because most of the students who are trying to understand what is international law, they often find it difficult to understand because in their minds they think of law as domestic law. So when they think about law, they think of Constitution of India, they think of Indian Criminal Code, Indian Penal Code, Criminal Procedure Code, Evidence Act, Contract Law, all of which are domestic laws. All of these regulate individual behavior, but not state behavior. So in that sense, the subject of international law and domestic law being different makes international law and domestic law function very differently from each other. And if we are mindful of this difference, which is a huge difference, we'll try to understand international law better, right? So my idea uh, with discussing international law and its nature with all of you is to not uh, not uh, not make all of you try to learn different things about international law, but then try to understand it organically. So if we understand this subject related difference between international law and domestic law, all other differences will follow from this and other differences. So you'll understand this better rather than just learning it without understanding the logic behind. So let us now see, with this background in our minds, let us now see what is the nature of international law and how it is different from national law. So when I say national law, it means domestic law. Domestic law is interchangeably used as national law, municipal law, local law, and otherwise. So what are the elements of international law? Let us first try to see what are the elements of a international legal system. Ordinarily, for a national legal system or domestic legal system, the elements of law are power, so the power of law, the authority of law, and this power and authority exert a duty or an obligation upon the entities. These entities, as I said, in case of domestic law, are individuals. So this power and authority of a law exerts some obligation upon the entities to follow that law, right? So there is this law that exudes some power or authority, and due to the power and authority of the law, there is an obligation. There's a person who's obliged to follow this law. So there's an obligation, and this obligation is non-voluntary. So you can't choose that I'm an Indian, so I'll choose whether I'll follow constitution or not. No, it does not happen like that. I'm an Indian, so I'll just choose whether I'll follow the provisions of Indian criminal laws, penal laws, etc. It does not happen like that. In case of domestic law, the laws have power and authority to oblige you to give an obligation, to impose an obligation upon all of us to follow that law. And this obligation is not that we choose, but there is a kind of coercion of law that, okay, you have to follow this. So traffic laws, you can't say that, no, I don't follow traffic laws, I don't want to wear helmet, right? You can't say that while driving in India, you can't say that I won't drive on the left side of the road, but I choose to drive in the center or on the right side. Under law, you're obliged to follow driving on the left side, to follow wearing helmet, to follow wearing seat belt while driving a car or any other four-wheeler. So laws are described with such elements. So these elements are very important pillars of defining a law. So if a law does not have power, so in normal understanding, it is thought so that if a law does not have power or authority, then how will it oblige individuals to follow that, right? So power, authority are very important to have coercion or obligation for the individuals to follow that law. So these are the basic elements that you find in domestic legal systems. Now, when we talk about international law, these elements which ordinarily are present in legal systems, national legal systems, are actually not so visible in international law. So when I say not so visible, I mean that international law, since it is a very different law than domestic law, that is why it does not function on the pillars of power, force, authority, obligation that states must follow this, etc. Now you'll say that why so? And if it is so, then how will international law be observed? See, in case of national legal systems, the point that we are born in India makes us follow the Constitution of India. The fact that we are born in India, this fact is well enough for the Indian Penal Code, the Indian Criminal Laws, Evidence Act, taxation related laws to apply on us. We don't choose it that way. But for states, which are in comparison of an individual, state is a very, very important high threshold political unit of international society. So therefore, a legal system that binds the state entity, which is a huge political unit, is unimaginable. So that is why the domestic laws, as I said, I used a word while describing whether you choose your constitution or not. I used a word non-voluntary. I said that domestic laws are non-voluntary. You can't say that I will choose to follow it or I'll not choose to follow it. That choice of following a domestic law is not there with individuals, right? Now, a very important point of difference between international law and domestic laws is that in international law, you have that choice. You have the choice of following an international law. So that means that a state may choose to follow a treaty, a convention, an international custom, or not. So, international treaty, custom, or convention, these are places where international law, international rules are there. So, international rules may be embodied in a treaty. We'll see this in detail further, but for our discussion, a treaty or convention is an international contract that contains some international rules or principles. So, whether a state has to follow this treaty or not is the choice of the state. It is the sovereign choice of the state. So, in that sense, international law is choice based, or it is a voluntary system of law. And this again is a very important distinction between international law and national law. So the fact that the subjects of national law don't choose the law, but the subject of international law, which are the states, primary subjects are state, they choose to follow which international law or not follow this international law. This is a very important point of distinction between international law and national law. And this point of distinction gives a very different uh, fabric to international law, right? So, international law in that sense is consent based. It is voluntary because states can voluntarily choose a law or not choose a law, right? Now, you'll say that why it is so, right? This is so because if you've studied about state and how state as a society is formed, there's several theories that describe it. One of the mainstream dominant popular theories that describe the relationship of individual with the state, Indian with India. So one of the very popular and dominant theories that describe it is social contract theory, which says that there is a hypothetical social contract between the government and the governed, that okay, now we will follow whatever laws or whatever rules are made by the government. So this kind of hypothetical social contract uh, is assumed. So in that sense, the individuals, hypothetically, each individual and those who will be born in future give away their the right to be governed to their governments, respective governments. So this is one of the theories that describes the relationship of the government and the governed in a society. But when you talk about international law, the states are sovereign entities. So I'm sure those of you who would have studied political science or civics in your school level education, you would have come across this word that states are sovereign. So states are independent and indivisible supreme authorities within themselves, within their own spheres. That makes no other foreign authority, by foreign I mean any authority outside the state, be it any other state or international law. So as state is a sovereign entity, that makes no other authority outside the state agency exert a power that, okay, you have to follow this law or you don't have to follow this law. And this idea of state sovereignty being supreme, absolute, a state being independent, not being governed by any other authority but the state itself, this idea posed a huge hurdle in development of international law. So this was seen that if state is supreme, then how it can be governed by international law? Which is when this idea was slightly changed, and it was said that it was understood in international society that yes, state is sovereign, but still if the state wishes, if the state chooses to follow a kind of international law, it can. Therefore, international law is a consent-based system where state, if consents, will follow a particular treaty. If it does not consent, then that treaty will not be applicable on that state. So at this level, this may sound absurd, but in our future lectures, this will become more clear to all of you. So I'll stop this point here because we'll discuss about treaties and conventions and about voluntariness of international law later in detail. But as of now, our takeaways from these discussion is that the elements of legal system, which are power, authority, obligation, coercion, etc., which are prominent in domestic law, are not so prominent or not so visible in international law. If present, these are very weak elements in international law. A second point, that the subject of international law, from which all other points emanate, is that the subject of international law, which are states, primarily states, and the subject of domestic law, which are individuals, that makes the nature of both the laws very different. A very important point for all of you to note here is that traditionally thinking, international law's primary subjects are state. So in its developmental time, when international law was being developed, it was understood that it is a law to regulate the behavior of states. But later on, with the development of international organizations, for example, League of the Nations, the United Nations, WTO, and other such international organizations, it was felt that international law is equally applicable to international organizations. So the subject of international law is not only states, but also international organizations. And in a very limited sense, only in few cases, the subject of international law is individuals also. Now you'll say how individuals are subject of international law. International law does not directly apply on us, right? But as I said, that in few cases, in limited sense. For example, if we take refugee law or asylum law or extradition law, these are few limited instances where the international law relating to refugees, international law relating to extradition, international law relating to asylum directly applies to individuals, those who are seeking refuge, those who are seeking, those who are to be extradited, or those who are asylum seekers, respectively, right? So for our understanding till now, the subject of international law primarily first would be the states, but secondary subjects are international organizations, and in a very limited sense, individuals, in few examples, would also be the subject of international law. While for national law, it will mostly be the individuals as subjects. Then one very important distinction again that emanates from our points of states being sovereign and states making international law a choice-based system or a voluntary system, is the point that international law is a horizontal law. I'll say how horizontal. So let me explain this with the opposite of this, vertical. So vertical authority. In case of domestic legislations, domestic laws. So if you take example of India, because most of us will be acquainted with Indian legal system, whether or not we have formally read it. So in case of India, there is central government, the state government, there is local self-government, and then there are the individuals. So there are laws that are passed by the central government, laws that are passed by the Parliament of India, which are applicable to all of us. Those laws may also be altered, added, or deleted upon, depending upon case to case basis from the state government. So, state governments may choose to add certain clause, certain provisions on those legislations which were passed by the parliament. That is, so they are known as central legislations. And then they are applicable on all of us, right? So, we are obliged to follow those legislations. So you see, there is a hierarchy or there is a vertical element of authority of law flowing from central government, the state, to each one of us, right? So, and this vertical authority is unidirectional. So we don't tell that, okay, you have to follow this, but it is about from the state. So state emanates law for each individual to follow. So this is unidirectional vertical authority of law. On the other hand, if we talk about international law has this horizontal authority where this horizontality comes from the fact that each state is equal, each state is sovereign, and they're based on the same platform. There's a level platform, so every state is equal in that sense. There's no state which tells other state to do this or not to do this. The states collectively come and negotiate a treaty containing an international rule and then decide whether to follow it or not. But then it's not like one state will tell other states to do this or not to do this. So in that sense, the international law is seen as a horizontal system, right? This also makes international law more decentralized, unlike domestic law, which is a centralized system. So in domestic law, we know the centrality of power, which is in the, as per the constitution, given to the parliament or the central government. And this centrality of authority, be it in the government or in the parliament as the legislature, is prominent in domestic legal system. But in international law, there's no centrality of law. The agency of international law is not centralized, but more of decentralized, right? So these are the important key points to note for defining the nature of international law. So let us move to the difference between public international law and private international. So public international law is that international law which regulates the behavior between states, about which we were discussing so far. So international law, where states are the subjects, is commonly known as public international law. When we talk about private international law sometimes is also known as a misnomer, because private international law does not pertain with states, but it deals with individuals of different states. That means that if there are two or more individuals who have different nationalities, so suppose person 1 who belongs to state A, person 2 who belongs to state B, person 3 who belongs to state C. So these 3 individuals are of different nationalities and they enter into a contract or any other similar relationship. And in case of dispute arising out of that contract, which law will be applicable in such situation, whether the law of state A will be applied or state B or state C. This is an example of a typical private international law matter. So private international law is a set of laws that deal with private individuals when there is an internationalizing factor. This internationalizing factor is different nationalities of individuals. In that sense, it is said as a misnomer because people say that there's no internationalizing factor. It's just about different nationality of private individuals. So private international law therefore is also known as conflict of laws, which describes private international law situations better because it is about conflict between different national laws, whether state A's laws will apply or state B's laws will apply. So it is more of conflict between national laws. Therefore, it is known as conflict of laws more accurately than the private international law. Although nowadays this kind of distinction is blurring because there are conventions like Hague Convention on private international law matters. So private international law, although it deals with private individuals from different nationalities, but this matter in terms of number of such situations are so huge that there are international conventions now to govern private international law matters, or now to show how model private international law documents can be adopted by the states. In that sense, for theoretical purposes, yes, these two are different, but then we may see that nowadays the difference between these two are blurring. So let us see now the kinds of public international law. These are just examples of public international law, and this is a non-exhaustive list. So one category of public international law is international human rights law. Another example would be international economic law. Another would be international humanitarian law, extradition law, refugee law, asylum law, law of seas, law of air and space, and otherwise. As I said, please note that these are not the all kinds of public international law. There are many more fields of public international law. And for our purposes of discussion and otherwise also, whenever you see the word used international law, it basically means public international law, not private international law. So let us now come to the sources of international law. What are the sources of international law? So the first source of international law is treaty, then international custom, then general principles of law, and then the judicial decisions and views of most highly qualified publicists. But how do we come to know that these are the sources of international law? So there's a document which constitutes the International Court of Justice situated at Hague. This document is known as Statute of International Court of Justice.